Good morning. This is Dr. Nelson Garias. I'm your professor, and this is the video lecture, MED230, Medical Law and Ethics, and this is for the class, the morning class, original date, Monday, October 24. Okay, well, last week when we went over Chapter 2, we kind of stopped near the end. And if you look at, we described the type of courts and felony versus misdemeanor, but we didn't, I'm adding this little bit here, not adding, but we were running out of time. So I'm just going to review a little bit. Now, I like some of these pictures here. These are nice little logic trees or thought diagrams, and, you know, they lead to things. So let's start looking at the trial process, okay? And we already talked about some of the torts. You have the intentional, you have to know these. What's the difference between slander and libel? We already know that. Well, we a little bit touched on administrative law, which is public law, and it's regulation, and it's typically government agencies, and you can look at this part as well. Well, we'll be talking about this part. How does the trial, if ever you get into a trial, how does it go down? We already now discussed this, the different types of courts. Here's another term that you need to know is jurisdiction. Who has the power to hear the case? But let's get into this stuff. Okay, the trial process. First, it starts off with a grand jury. They are a set of people who will decide if there's enough evidence to continue, because there's a lot of litigation, there's a lot of court. Remember, we talked about that you could be sued for anything. You could be sued legally for a candy bar. But the grand jury sees that, is there enough evidence to continue? And also, the grand jury, held in private, and the plaintiff and the defendant get together. Know who the defendant is when you see cases, and know who the plaintiff is. And remember, if it is a tort, it is against individuals. If it is a criminal case, it is pretty much society or the Commonwealth versus that particular individual. Now, the grand jury votes, and if there is an indictment, that means there's a formal legal charge to the defendant, and then it goes to trial. Again, the word litigation, you know who the plaintiff is, prosecutor. Those are nice little terms. Let's talk about the subpoena. Legally, you cannot give up the medical file, ever. The medical file is not the property of the physician, it's not the property of the patient, it's the property of the facility. The only way you give it up is if there is a legal document, and that legal document is a subpoena. It is a written command from the court. And an example, if you see here, and it's on page 47 or so. Subpoena duces tecum means under the penalty take with you. That means it has to be a specific thing. I mean, they could say the entire chart, but they have to designate. The court itself has to designate which exact parts of the chart. But if they say, oh, the whole entire chart, they'll define it. So this is part and parcel of another term is discovery. Both sides have to divulge everything. They can't hide anything. That's against the law. Okay? So subpoena duces tecum. It literally means goes under penalty, take with you. You'll be in contempt of court if you do not submit the exact documents. All right? Now, summary judgment. Okay? Start thinking civil lawsuit, start thinking some sort of tort, and then there's closing arguments. Closing arguments, of course, is the last things that both sides says in a court. And we kind of discussed this a little bit, that the standard of proof or the burden of proof, remember, if it's criminal, it must be the preponderance. If it's civil, sorry, rewind, scratch that. If it is a civil case, there must be a preponderance of evidence, 51% has to be in favor to win. But if it's criminal, it has to be without a doubt. Expert witnesses, that came out on the CMA when I took it. And who is that person? And you know and read the parts that the pros and cons on having an expert testimony. In my professional experience, most juries, most lawyers do not like the expert witness because, again, you can always find another expert, and then it becomes highly subjective. Which expert do you listen to? All right. Now, if they call you in because you're a medical professional, there's nice little hints. But ultimately, always tell the truth. Do not embellish. Don't get fancy. Just tell them exactly how everything goes down. So that's the last part of I believe it's chapter 1 that we kind of glossed over. So that's why I reviewed it. Now, what are we doing today? Week 3. So week 3, we just went over legal systems. Now we're going to talk about chapters 5 and chapter 6, which is patient relationship and professional liability. So let's just jump to 5, and it's in part 2. So let's jump to 5. Okay. Of course, define the glossary terms, rights of the doctor, the 9 principles of medical ethics is designed by the American Medical Association, and a summary of the patient's Bill of Rights. Understand and care how the practice of medicine, how it is applied, of course, the Bill of Rights. Self-determination. Remember, we are not the masters of healthcare. We just simply give our patients options, and the patient gets to decide on their own. Describe the difference between implied consent and informed consent. We went over this a little bit in the other class. So know these terms, and during our case, during these cases, of course, the case will most likely be your homework. Okay, but we will have work today, and that will be announced in Moodle and on the board as classwork, and will, if I am unable to get to class on time before the end, that'll be used as your attendance. So let's look at chapter 5. Okay. The doctor has rights. We have the duty to serve our patients, but we also have rights on our end as well. And we mentioned some of those in class before. If my patient is being belligerent, if my patient's not listening to me and doesn't take my advice, then I have the right to stop service. Okay, but there is due process. That's another term you need to know. You can't just stop treating your patient. It has to be done formally, and we're going to talk about that. If you look at the AMA or American Medical Association's Principle of Medical Ethics, you'll see that there's these common things: human dignity, honesty, confidentiality, continued study, freedom of choice. Sounds familiar, doesn't it? So look at the table. There's a really nice table in there in 5.2, and it lays out a physician's duties. For example, conflict of interest. You can't get kickbacks from drug companies. Professional courtesy. if you, and that's the neat thing about being in medical, most other doctors will waive their professional fees. Professional fees can be in the thousands, especially if the physician is a specialist. But if you're one of us, you know, a medical professional and a recognized medical professional, most doctors will waive that fee. You have to report unethical issues. You have to supply second opinions from other colleagues who may or may not even be in direct competition with your office business-wise. Sexual conduct. We talked about that. No matter how cute your patient is, or the granddaughter of your patient, or the grandson of your patient, you cannot hang out with them. There is an anti-fraternization form that's in most places, and including this place. Treating family members, again, we talked about that. That is really difficult because, again, it ruins the objectivity. All right. We talked about emergency procedures, right? We cannot turn away a patient because it is implied consent that if the patient is unconscious, they would want to be serviced. Okay, but if the patient wakes up and says no, or it's obvious they're fighting you, no, then we can't do that. Duty to treat indigent patients. Okay, you can't dumping crisis. Sometimes they even call it turfing. The two government programs, COBRA and EMTALA. EMTALA was on the CMA and also was on the RMA reviewer. They have to do with what happens when you don't have money to pay, and that's the indigent patient. And again, in real life, a lot of doctors kind of shy away from Medicaid patient, but you know, we make it our duty to, if we can't see them, we try to get them the best possible care and try to find them like a free clinic or a free program. Abandonment, we cannot leave our patient, you can't leave them alone, and we can't just stop treating them. Okay, so read that part. We just talked about AMA, against medical advice, the pink form. If my patient's not listening to me, if my patient is incompetent and cannot give me proper consent, I have to find out who is talking legally on behalf of the patient. Because remember, because informed consent and contracts require someone who understands the contract and understands the procedures. Even if the person is an adult and doesn't understand the procedure, I really don't have consent. And that's already a red flag. It's already dangerous. AIDS, HIV, we already talked about that. It doesn't matter. My patient could have the bubonic plague. I have the duty and the sworn duty to go help my patient. Of course, am I going to have every precaution in the world? Yes, I am. HIV, you can read through that. Of course, your PPE. You must identify the patient. Remember, the 2 PHI are protected health information. That is most common is the patient's date of birth and the patient's social security number. Be careful when you talk to the patient regarding the social security number. Just get the last 4 digits. Especially the older, more responsible patients will be a little bit wary about that because of identity theft. Okay. Respect confidentiality. Remember HIPAA, Health Information Portability and Accountability Act. Portability and accountability. It looks like a beautiful both A and B question. So HIPAA, number 1, portability, just like COBRA on the indigent patient. You could carry your health insurance wherever you go. So you move from job A to job B, you can utilize COBRA to move from to bridge the gap between when you're between jobs, because you can't predict when you get sick. But what was I talking about? But the other part of HIPAA is the accountability. The physician, the medical professional will get into legal trouble if you divulge things to people who don't really need to know the story. A biller doesn't need to know the social history of my patient. Duty to tell the truth, of course, that comes without, common sense. So let's look at patients' rights. What do they have a right to? And I think one of those things is, of course, HIPAA, privileged communication. Remember, the only people you have to talk to are the designated people. So if they have somebody who is their attorney or power of attorney, and the patient legally and formally declares that person, you have to talk to that person and not my mom, that's or you have to talk to my mom and not my lawyer, that kind of thing. Self-determination or advanced directives. You could name a lawyer, you could name other people as a proxy. Now, advanced directive is really important because you cannot guarantee if you'll be conscious. You cannot guarantee if you're going to be loopy, or what they term as non-compos mentis. That means the person is of not sound mind and has no sound body at the time. So, for example, I'm in an emergency situation. I am partially unconscious, partially conscious. Do you think I can make decisions? I can't. So I have a legal document, written statement, an advance directive, naming a proxy who would speak for me in my place, both medically and financially. Okay, most likely it's next of kin, like my wife, but in my advance directive, which is a legal document, I name my mother, because my wife, albeit she's good at medical, she's not good at clinical stuff. My mother's a physician, she'll be the better person to talk to the other doctors. And they are proxies, another person who can make decisions on behalf of me. And then advance directive is the written legal statement, it's on a piece of paper, that defines the proxy, that defines the situations. And these are nice documents to have around, something to think about the future. You cannot predict how you're going to end up. So that thing should be out there. Look at the table of Bill of Rights, and a lot of it was kind of redundant in the things that we were talking about. Here are some examples of advance directives. Living will, durable power of attorney, uniform anatomical gift act, right? You know when you fill out the back of your driver's license, whether you're going to be a donor or not. There's a form connected to that, and that's the Uniform Anatomical Gift Act that states that's what that form. DNR, really important. Do not resuscitate. Remember, read your chart before you walk in the room. Patient codes, you bring them back, and then you realize, wait a minute, I didn't read the chart. It said DNR. They shouldn't be resuscitated. There shouldn't be extraordinary means to keep somebody alive. Living will, again, another document, and so think the word advance directive, right, is a generalized term, and these particular things are more specific. So, of course, living will, do not resuscitate. You have durable power of attorney. And here's some samples. Okay. Rights of minors. Okay. Now, there's exceptions to that. Most states, if you're under 18, you're a minor, and there must be consent of the parents or whoever your guardians. And here are the exceptions. Pregnancy, you become an emancipated minor. That means you now have all the stuff that all the rights and privileges of a 21-year-old because you're now a mommy. Military is another one. Or let's say, for example, you're Miley Cyrus, you're making $200 million a year, right? You want to be able to control your money, not your parents. And actually, that's what she did a couple years back. she parted ways with her father and his management, so she went to court so that she has all her money is now hers, and she doesn't have to share it with her father, unless she, and she would be responsible for that. So look at the last line there. The physician must secure the consent of the parents, right? Also known as in loco parentis. Loco doesn't mean crazy there. It means it goes in the location of the parents, or the person standing for, not physically standing, but representing. Parents patriae, related as well, because when it states that the parents have the right if the patient is under 18. But remember, the exceptions are emancipated minors, and we already have those examples. Okay. Consent. You have informed or expressed. That means it's out there. It's either verbal or written, and you have witnesses. Here's parts and parcels. I always like saying that. Patient signs and consent form. You can look over that. Implied consent. We already have an example of it. Emergency room, unconscious patient. Very classic. Here's some exceptions. Refusal. Remember, the patient can refuse at any time. Okay? Now that was, I went through it pretty quick, so you can look at it piecemeal at home or while you're in class today. Now, your assignment is to make an outline of all the items that I went through. Submit. It goes submit. You can either handwrite it or print it out, and make sure you submit it today. Your class day, which is week 3, October 24, 2016, and just place it there. And that's assuming if I don't come back from my off-site meeting, but I'm planning to be back as so that I could lecture Chapter 6, which is professional liability and medical malpractice. Okay, with that being said, good luck. I hope I see you in class.